Hello, everybody. Welcome to the 4th International Conference on Access to Legal Aid in Criminal Justice Systems. As you know, this event, ILAC in short, is co-hosted by the Public Defender's Office of the State of Rio de Janeiro, together with the International Legal Foundation, the Open Society Justice Initiative, the United Nations Development Program, and the United Nations Office on Drugs and Crime. Please allow me to share some technical remarks with you when we start the session. This webinar is recorded and it may be shared on social media. There may be experts joining today from countries all around the world, and we invite you to use the chat function of Zoom if you can, if you want to add comments, share experiences, and we would be very happy if you could introduce yourselves in the chat so we know that you made it. We are very excited to have you, and we also have a questions and answers feature that's also on the Zoom taskbar, where you can submit any question that you can think of and it will be answered live. By default, all of you are on mute and our technicians will unmute the speakers as they speak. We are very excited to offer you translation into French and Arabic. You find that at the interpretation button on the Zoom toolbar. And I just want you to alert that Arabic is in the Japanese channel. So if you choose Japanese, you will have Arabic. Okay, now that we have the housekeeping done, it is my pleasure to welcome you all to this panel on advocating for release and protecting the rights of people deprived of liberty. That is part of ILAC 4 that we can hold this year as a special virtual convening amidst the pandemic, to help increase access to justice for all around the world. UNODC that I am representing, my name is Annika Holterhoff, and I am the focal point on legal aid in our main office in Vienna, is honored to be once more co-host of this conference together with UNDP, ILF, and OSJI, and I would very much like to thank the Public Defender's Office of Rio de Janeiro for their tireless work on making this possible, because we thought that we would not be able to convene this meeting in the pandemic, and yet here we are. I would also like to thank particularly Mr. Andre Castro, who many of you may already know, for the leadership in this. We are holding this panel today for the time zones of Africa and Europe, and we have 5 distinguished expert speakers who will share their views with you. Actually, we have 6 if you count that one pair will share the intervention space. And I would like to very warmly welcome Ms. Olivia Rope, the Director of Policy and International Advocacy at Penal Reform International. Then she will be followed by Mr. Bruno Langondry, who is an expert on access to justice and detention, and his colleague, Ms. Joëlle Riziki, who is a project coordinator in the Democratic Republic of the Congo, and they are both representing Avocats Sans Frontières. Then finally, we will have Ms. Natalie Fragoso, who is a human rights lawyer and a member of the Human Rights Lawyers Collective. We have then Dr. Amar Dwaik, General Director at the Independent Commission for Human Rights in Palestine. And we have Mr. Mabrouk Koualdi, Director of Criminal Cases and Human Rights at the General Committee for Prisons and Rehabilitation at the Ministry of Justice of Tunisia. I am also very honored to be here with you today, the audience, and while we all very much regret that we cannot be in the beautiful city of Rio de Janeiro today and continue our discussions in the breaks, we are anyway having a record participation this year of over 500 people from 75 countries that have registered, and I'm happy to see that many of you are attending this panel today. As we were reminded yesterday, equal access to justice for all is a prominent feature of the 2030 agenda. And we all know that legal aid in this context is key. And it's also ensuring the main objective of the agenda, to leave no one behind. The pandemic put a spotlight on the vulnerability of many people, but particularly one group of people that we already knew were facing a very high risk of violating of their rights in the normal world that COVID put upside down. And these people are the detained, the arrested and imprisoned, the suspected, the accused of, and those charged with a criminal offense. And legal aid makes such a difference in these people's lives and enables them to navigate the very complicated criminal justice system. And it also impacts their families and their communities because it helps the time that they are held in detention, the number of wrongful convictions, mismanagement, and many other issues, including reoffending, which makes them end up in prison again. And all these crucial effects of legal aid gained a whole new meaning in 2020 when justice systems and prison management faced unprecedented challenges. So our panelists today will address different aspects of how COVID effects and responses have influenced the prison context in different regions of the world. And after they have spoken, depending on how much time we are very happy to have a questions and answer session where you can ask questions, and we really hope that you will benefit from this session. And without losing further time, I would like to invite our first panelist, Ms. Olivia Rope, the Director of Policy and International Advocacy at Penal Reform International, to the floor. She holds an LLM in international and European human rights law and is a barrister and a solicitor admitted to the High Court of New Zealand. At PRI, she leads on policy setting and advocacy, and she works on a range of human rights and criminal justice issues and also acts as the spokesperson for PRI at the international level. She has authored many key publications and training materials, and she worked extensively with probably many of your organizations represented here today. She previously held positions at Amnesty International, and today she will talk about restrictive regimes and measures that brought in with the coronavirus pandemic in places of detention all over the world, in particular those that refer to solitary confinement, and she will explain the implications on the right to access to legal counsel. She will highlight good examples, and she will share recommendations from PRI for lifting restrictions and longer-term systemic reform. Olivia, you have the floor.
Thank you so much, Anika, for the kind introduction, and it's very much my honour to be on this panel today. As you mentioned, it is a difficult and unprecedented time. And so today I want to spend a little bit of time reflecting on what we've seen at PRI as the key trends in justice systems, and particularly in places of detention that have been brought with the pandemic. Firstly, if we look at the impact on the lives and health of people in detention, we can see from a live global mapping that's maintained by Justice Project Pakistan that almost 200,000 people have contracted the virus in prisons in over 100 countries, and over 2,100 people in prison have been recorded as having died due to COVID in 40 countries' prison systems. But this is just what we know about. In reality, the numbers would be much higher. The reason why we don't know this is that we lack reliable data. There's limited or no testing in places of detention. And this is compounded by a lack of transparency around data in many countries. In almost every prison system, we've seen that the response to the pandemic has involved some form of extreme restriction of movement within facilities. And this has either been for the whole facility, groups of individuals, or at the individual level. And while medical isolation may legitimately involve separation of a person from the rest of the prison population if they show signs of or they test positive for COVID-19 to prevent further transmission, we in many cases have seen that people have faced 23 hours or more in their cells a day based on an assessment by regular prison staff. And this is in effect solitary confinement, as defined by the Nelson Mandela rules, which is the confinement of somebody for 22 hours or more a day without meaningful human contact. The rules stipulate that such a regime can only be imposed in exceptional cases as a last resort and for as short a time as possible. Significantly prolonged solitary confinement, which is defined as this regime in excess of 15 consecutive days, is a threshold that many of the restrictions in place is meeting. And prolonged solitary confinement is prohibited in the Mandela rules and amounts to torture or other ill treatment. So these regimes, and where blanket bans on visitation and contact to the outside world in person, has affected access to legal representation for people in detention. This access has at best become strained and limited, or more bureaucratic to manage, and at worst completely impossible to realise. As we all know, the right to legal advice is a basic component of the right to a fair trial and many other rights. And that is why the Mandela rules lay out the modalities and the entitlements governing access to legal representation for people detained. And even in a time of emergency like the COVID-19 pandemic, the Mandela rules and other international standards are applicable, and in fact they should be looked to for guidance in preparedness and response plans. Without access to legal counsel, people cannot challenge their detention, which has a whole host of issues, including higher rates of overcrowding and higher risks of COVID-19 outbreaks. External scrutiny and confidential meetings between legal counsel and people in detention also help to address and prevent ill treatment and other forms of violence. And practically speaking, we've noted that some of the COVID-19 prison release mechanisms have very strict conditions on people who can benefit from them, including obeying the public health measures in place, which are not always straightforward. So legal aid representatives play an important part in accessing these release mechanisms and explaining the conditions. So while some adaptations in prison systems may be necessary because of the pandemic, these limits must be proportionate, they must be legal, and they must be necessary. So as the goal is to prevent or respond to any outbreak of coronavirus, ultimately the decision-making around such measures must be led by healthcare practitioners based on COVID-19 clinical evidence. And unfortunately, in many cases, this is not the case. To give one example, one policy saw people being allowed out of their cells for 20 minutes a day where they had to decide between calling their family, their lawyer, or having a shower. There have been some positive measures that I can mention. For example, in Kazakhstan, video calls were introduced to supplement phone calls, and the prison service set up a call centre where lawyers and others could contact people in detention. In Kyrgyzstan, next door, free legal aid was provided through phone, social media, and email. Such IT solutions are becoming the norm, but they should really be temporary or supplementary. And months on from the start of the pandemic, our recommendations are really around urgent reviews of what is in place. They cannot become the norm, such measures. So there needs to be an assessment around whether access to legal counsel can be made in person. And are the restrictions and the extra bureaucracy that we've seen in many places really necessary to prevent any outbreak? If community transmission levels of COVID-19 are low, is it really necessary to limit or require PPE for lawyers who cannot always access such equipment? So where to now? And I will end on a couple of remarks, as I know time is short, as to where we see that the real change is needed. In some ways, the pandemic has reignited discussions on how to make justice systems more efficient, more innovative, but fundamentally, we need less people in the system. We need less people in detention. The global prison population has now reached record levels. And in fact, the release mechanisms that we have seen, which saw around 6% of the global prison population released, which is certainly not adequate, shows that perhaps a lot of these people do not need to be in detention in the first place. And the fact that lockdowns are continuing in many contexts, even in high income states, which is affecting legal aid and among other things, is sadly an indication of low funding and equally low political will to invest in prisons. As we know, with a package of measures, which includes lowering prison populations, staff training, the provision of equipment and testing and healthcare, along with some small adjustments to the prison regime, lockdowns can be ended and can be prevented in the future. So I will leave it there and I look forward to your questions later on. Thanks, Anika.
Thank you very much, Olivia. That touched really upon some of the most important points that we can make in this context, that the measures should be temporary, supplementary, and legal. And I'm very happy that you also mentioned the Nelson Mandela rules, which, as you know, UNODC is a guardian of, and we are really happy to see that many experts, including yourselves, have also used the new provisions that they contain on access to a lawyer for prisoners at several different stages of their commitment and their imprisonment in the context of COVID-19. And the remarks that you made at the end read like a bullet point list of what every state should look at. So thank you very much for that. And now we move on to our two speakers from Avocats Sans Frontières, Lawyers Without Borders. And I would like to say about both of them some points on their biography, and then I would just let them speak so we do not have to interrupt them. Starting will be Mr. Bruno Langondry. He's the head of the Knowledge and Learning Department. And he previously worked as a lawyer in Belgium, and at ASF he focuses on access to justice and detention issues. He joined the organization in 2014 and since then has developed a lot of expertise in various regions, including the regions that are important for our panel today, North Africa, Central Africa, as well as Southeast Asia, where he did a lot of field research. He supported the local teams and partners that were implementing projects and coordinated international communities of practitioners that help combat human rights violations in the countries, particularly in prisons. He also, before he joined ASF, was the president of the Legal Coordination Committee for the Belgian section of Amnesty International. He is joined by Ms. Joëlle Riziki, I hope I'm saying this right, who is a lawyer working for the ASF office in Kinshasa in the Democratic Republic of the Congo. And she implements projects there that protect the rights of detainees and human rights defenders. And her actions are in several regions of the country, including the capital, where she also facilitates partnerships with civil society organizations and the local bar associations. She coordinates a team of lawyers who advocate for the effectiveness of human rights in prisons, in particular during the time of the pandemic. Bruno and Joëlle will discuss how the detention experience, with PEER in capital letters, network of around 100 lawyers and practitioners committed to the protection of human rights in prisons following the pandemic, advocated to protect the rights of detainees with 40 NGOs in Africa in 15 different countries. And they will also focus on the situation in the Congo and on specific actions there. So Bruno, please, you have the floor.
Merci beaucoup Anika. Merci beaucoup à tous les... Je reprends. Voilà. Ma collègue Joëlle éprouve des difficultés à se connecter, donc après ma présentation, je vais chercher à lui passer la parole, mais si ça ne fonctionne pas, eh bien, j'essaierai de parler en son nom, même si je suis un peu moins bien préparé. Mais d'abord, je voulais remercier toutes les organisations et les personnes qui sont derrière d'avoir invité ASF pour partager les actions qui ont été menées durant cette période de pandémie. Alors, je vais d'abord présenter un cadre plus général avant que ma collègue aborde la situation spécifique en RDC. Et donc pour cela, j'aimerais remonter au début de l'année 2020 où, comme Annika l'a mentionné, nous avons lancé le réseau Detention Experience qui vise à rassembler des avocats et des spécialistes du droit de la détention qui agissent de façon autonome. Et donc ce réseau a pour objet, au-delà de fournir l'aide légale aux détenus, eh bien, de mener des actions pour influencer positivement le fonctionnement du système pénal. Donc, ce réseau porte des actions de plaidoyer et des actions judiciaires en responsabilité de l'État pour détention arbitraire ou pour violation des conditions de détention. Donc, comment ça fonctionne? Au niveau local, avec des rencontres en direct, mais pour agir de façon continue et accroître les échanges internationaux, on a mis en place une plateforme digitale dont on espère à moyen terme, d'ici 2021, qu'elle pourra accueillir plus de monde et s'étendre. Alors, ce réseau, lorsque la crise a commencé au mois de mars pour l'Europe et l'Afrique, eh bien, ce réseau s'est mobilisé et densifié pour promouvoir le respect des droits des détenus qui se trouvaient encore davantage fragilisés. Alors, qu'est-ce qui a été fait concrètement? D'abord, un cadre d'action internationale a été mis en place avec une quarantaine d'ONG issues d'une vingtaine de pays, essentiellement francophones, mais également des pays anglophones, qui ont développé un plaidoyer commun, ensuite traduit dans des actions d'influence au niveau local. À côté de ces actions de plaidoyer, des initiatives de terrain ont été menées en complémentarité à l'assistance judiciaire existante par le développement de requêtes de mise en liberté standardisées, en collaboration avec les mouvements d'avocats en Europe, mais faisant ici état du droit et de la jurisprudence de droit international africain. Ma collègue Joël, normalement, vous donnera un aperçu des résultats de ces actions pour la République démocratique du Congo. Alors, à côté de ces actions de plaidoyer, des actions de monitoring, de suivi et d'évaluation de la situation ont été menées dans différents pays, spécifiquement au Burundi, en Centrafrique, en RDC, en Ouganda, en Tunisie, mais également en France, en Belgique et en Italie. Alors, le monitoring est toujours en cours. Il est encore un peu tôt pour partager des analyses finalisées, mais je peux déjà partager quelques lignes directrices de cette analyse. Alors, au registre des mesures défavorables, des effets défavorables des mesures d'urgence qui ont été prises, il y a d'abord une constante, c'est la fragilisation des détenus et donc l'isolement accentué, notamment par la suppression des visites qui a été généralisée sans suffisamment de recherche d'alternatives pour leur permettre d'avoir accès à leurs proches et aux ressources alimentaires de base. On a aussi constaté, de façon plus ou moins générale, la suspension ou la limitation, ponctuelle ou dans la durée, des audiences des tribunaux, qui ont un impact défavorable sur la pression carcérale et accentuent l'arriéré judiciaire. On a également vu de nombreux cas d'arrestation dans 2/3 des pays observés et de placement en détention de détenus qui ne respectaient pas le confinement et donc qui ont eu aussi un impact sur la population carcérale. Alors, au registre des mesures qui sont à saluer, on a régulièrement vu dans beaucoup de pays la recherche d'une régulation, voire d'une baisse de la pression carcérale dans plusieurs pays, malheureusement souvent en prenant des décisions ponctuelles qui n'ont pas d'impact sur le long terme, comme des mesures de grâce présidentielle ou des amnisties. Dans certains cas, des bonnes pratiques ont été observées qui sont plus structurantes dans la durée. Ça a été le cas en Tunisie, ça a été le cas en RDC, où des actions de l'administration pour que les magistrats ou les directeurs de prison appliquent des mesures de désengorgement ont eu lieu. Par exemple, au Nord Kivu, en RDC, une commission provinciale mixte a été mise en place pour appliquer des mesures préventives. Elle a permis aussi d'identifier les détenus fragilisés et accélérer leur remise en liberté et d'identifier les dossiers bénéficiant d'une libération conditionnelle. Alors, sans doute que l'expérience de l'Est du Congo dans la gestion de crises sanitaires antérieures, comme celle d'Ebola, a permis de prendre conscience des enjeux et de réagir plus rapidement. Mais quoi qu'il en soit, ce type d'initiatives plus structurantes sont vraiment à saluer parce qu'elles sont potentiellement applicables dans la durée et pas uniquement pendant la crise, mais pour toute situation grave qui fragilise les droits fondamentaux des détenus. Alors, beaucoup de choses sont encore à dire, mais seront compilées dans un rapport qui sera disponible normalement assez rapidement sur notre site www.asf.be. On l'espère dès la mi-octobre. Je laisse la parole à ma collègue Joëlle si elle arrive à se connecter.
Okay, Bruno, if you would like to continue while we try to get her on the line, that would be great. If you can maybe make a few points. Thank you.
Et peut-être je vais reprendre malheureusement, et si Joël, tu parviens à te connecter, n'hésite pas à m'interrompre. Et donc, mais voilà, l'idée de vous présenter brièvement un focus sur la situation en RDC, où il faut d'abord noter que la crise, finalement, d'abord était un amplificateur d'une situation qui est déjà vraiment alarmante, hein, dans un pays où régulièrement 75 à 80% des détenus sont en attente d'un jugement. Donc, rien que pour prendre la prison de Makala, qui est la prison centrale de Kinshasa, et qui compte aujourd'hui 600% de taux d'occupation, et où on relate quelques 15 détenus décédés par mois. Alors, dans un tel contexte qui sert effectivement d'incubateur à l'aggravation de la situation des détenus, eh bien, plusieurs actions ont été menées, mais plusieurs que j'ai citées et qui se sont inscrites dans ce cadre général. Mais peut-être regarder un peu sur les actions contentieuses qui ont été mises en œuvre dans le cadre de l'aide légale. Donc, des requêtes sollicitant la mise en liberté ont été introduites. Alors, certes, le travail a été rendu plus difficile suite à la suspension des audiences, mais les avocats, lorsqu'ils ont pu travailler dans les provinces de Kinshasa, dans les villes de Kinshasa, Goma, mais aussi au Kasaï ou au Katanga, avec les barreaux partenaires des projets, ont proposé une assistance judiciaire et ont pu porter assistance à 262 détenus. Avec, et c'est à noter, un taux de libération qui était plus encourageant que celui qu'on avait précédemment hors période pandémique, donc ce qui démontre quand même la prise en compte de la part des juridictions de la situation. Donc pour un taux où il y a un effet positif sur les requêtes, en général par une fixation au fond ou par la libération des détenus de quelques 50%, et bien ici, des taux de libération avoisinant les 75% ont été obtenus durant cette période, mais ces chiffres doivent encore être consolidés parce que la situation est en cours. Alors, les barreaux ont également été invités à se rapprocher des administrations pénitentiaires pour pouvoir favoriser la communication entre les avocats et les détenus via des téléphones portables. Et donc, il y a eu un travail de rapprochement qui est à saluer entre les barreaux et l'administration pénitentiaire. Alors, un petit bémol, dans la situation où régulièrement on constate une dynamique de corruption ou d'extorsion qui est relativement importante. On a constaté dans certaines administrations pénitentiaires la nécessité ou des demandes formulées par les directeurs ou des fonctionnaires de la prison de rémunérer davantage les autorités pour pouvoir accéder aux détenus. Et donc ici, je conclurai peut-être cette présentation pour noter que il est clair que, comme je le disais, la crise a servi d'amplificateur à cette situation. Elle a été un frein immense à l'accès à la justice par rapport au travail qui peut être fait. Mais on a regardé que le travail de plaidoyer des organisations de la société civile, des avocats, a permis de faire bouger quelques lignes dans le traitement des questions liées à la détention, et notamment à travers ces initiatives qui visent à réduire la pression carcérale. Et la question, elle se pose aujourd'hui, mais finalement, si dans cette période pandémique, il y a moyen de pouvoir parler davantage de la condition des détenus, il faut pouvoir le faire dans la durée et responsabiliser les autorités en ce sens. Merci beaucoup.
Thank you very much. That was very interesting, and it's important really to see that in countries where the rates of prisoners are even higher than in other places, the utmost is done really also including civil society to advocate for the rights of inmates, including what you said, to protect them from the effects of the limitation of hearings and not being able to communicate with their families, and really to think of who can be released and to have all these measures have a positive effect on the system in the long term. I am sorry that Joelle could not join, but very thankful that you could make some remarks on her behalf. Now we will move to Ms. Natalie Fragoso, a human rights lawyer and member of the Human Rights Lawyers Collective, CADHU, the abbreviation, who holds a degree and a PhD in law from the Law School of the University of Sao Paulo, as well as a certificate on the foundations of German law and an LLM of the University of Munich. She is the head of research on privacy and surveillance at the Internet Lab, and past assignments of hers include a variety of issues, including heading the Luis Gama Human Rights Clinic and advocating at the Institute for the Defense of the Right of Defense. So very much what we are all about here. And Natalie will talk about the work of the Human Rights Collective, and it is the first one that was admitted by the Federal Supreme Court of Brazil, and how it paved the way to address collective issues that are related to the prison and the criminal justice system. She will also share with us how the collective, how the work has continued during the pandemic and what has been done. Dear Natalie, you have the floor.
Thank you very much. I have some slides I'd like to share with you all. So if maybe the tech team would help me with that. Thank you very much. So good morning, good afternoon, good evening. If you're like me in Brazil, it's still very early in the morning, but it's a huge honor to be here sharing the history of the first collective habeas corpus in Brazil, which was presented in 2017 by the CADU, which is a human rights lawyers collective. You can pass the slide, please. I'd like to share some facts, some elements of the context in which we found ourselves before presenting the first collective habeas corpus admitted by the Brazilian Federal Supreme Court. Although the number of women incarcerated in Brazil may seem small compared to the whole prison population, it has been growing in a very fast way. We are also talking about a very selective prison, criminal justice system. The majority of women in prison in Brazil are Black. We are also talking about deprivation of liberty which impacts the women in a lot of other ways. We are talking about the loss of the custody of their children. We are talking about the lack of adequate access to prenatal care, to health care, to exams which would prevent, for example, the transmission of syphilis, of HIV. We are talking about overcrowded spaces, sometimes violent spaces. We are talking about women giving birth alone in their cells or in handcuffs, for example. So in face of that situation, we are geared, you can pass the slide, please. We are geared before the Supreme Court that all the women which were under provisional, under temporary custody should be released because their prison, their deprivation of liberty in such a context was illegal, was beyond the constitutional limits of what legal deprivation, legal and legitimate, reasonable deprivation of liberty means. So we asked for the immediate liberation or alternatively the home arrest of these women. And it was granted. It was granted in 2018 in favor of all pregnant women, puerperal women, or mothers of children up to 12 years old under provisional arrest, as well as in favor of the children themselves, which were held in custody with their mothers in the first month of life and made for some years, or were sent to institutions where they had no access to the community, to their families, to the care that they deserve. So you can pass the slide, please. Can you pass the slide, please? It was difficult back then for the Supreme Court, but also for the other judiciary organs to understand that collective habeas corpus could be admitted, because the criminal issues were always processed in an individualized manner. But we argued that when we are talking about an abusive act, which has collective effects, collective impacts, the solution, the remedy should also be collective. We are talking about prison facilities which are overcrowded. We are talking about prison facilities which are violent. We are talking about an environment which are environments which are not healthy for children. We are talking about a lot of issues which are collective, which are repeated in a systematic way. So in order to address it properly, the Brazilian judiciary system should look at this situation, that state of affairs, in a systematic way also. If the abusive act has a collective impact, we said, an individual constitutional remedy, such as the traditional habeas corpus, would obscure the causes, would weaken the patients, the people affected, and would lead to the persistence of illegality. We are talking in this event about access to justice, and that's one other element that we highlighted in this action, because we are talking about people who lack proper access to justice. And it was very interesting to see how the public defender's office immediately have joined us from all the states in Brazil, arguing, first of all, strengthening our argument, bringing data from their states, and demonstrating interest in joining the cause and joining this movement for the collective remedy of the many questions involved in the deprivation of liberty of women. You can pass the slide, please. As I said before, the imposition of the preventive imprisonment on these women, their confinement before criminal conviction, which should be exceptional under the Brazilian law, in such establishments as the Brazilian prison facilities, would remove their access to prenatal health care, regular childbirth, postpartum care, reasonable conditions of hygiene and self-care, and would deprive the children of adequate conditions of development. And because it is so, it should be considered in an illegal act, repeatedly committed by the Brazilian judiciary. As I said, the fact that the inadequacy of the prison facilities and the discriminatory criminal justice, the discriminatory public security policies would have a disproportionate impact on women, on their children, on their families, on their surroundings, and so it should be considered illegal and unconstitutional under the Brazilian law. You can pass, please. Since then, and that's why, as Anika introduced the theme I would talk about, a lot of collective habeas corpus have been presented. Some of them by CADU, which is the human rights collective I'm a member of, but also and especially by the public defender's office. We are talking about the habeas corpus in favor of children who are held in juvenile facilities, and in this habeas corpus, which was granted actually, which was a very happy occasion, the overcrowding of such facilities was forbidden by the Brazilian Supreme Court. Also, there is a recent case on minor drug offenses in which it was forbidden. In Brazil, for example, if you are convicted for a minor drug offense, you have the right to start serving your time in an open regime. But it was being disrespected repeatedly by the judges in the state of São Paulo. So it was determined that people convicted for minor drug offenses should start serving the time in the open regime. And there is also a lot of other initiatives regarding prison conditions, period of sunbath, and the examples are many. So what I'd like to highlight here is that this way that was paved by the first collective habeas corpus in Brazil has been walked through by other institutions, by other actors, trying to face the prison conditions in Brazil by what it is, a collective problem, a collective issue, which have impact on many people and which cannot be solved by defending them one by one. Next slide, please. Next slide, please. I'd like to finalize my speech. I'd like to talk about the COVID pandemic and the situation in Brazil. As we know, and as it was said before me, we lack transparency. We do not have reliable data on the number of infected people. We do not have enough testing. We do not have adequate health care in the prison facilities in Brazil. We did not have it before the pandemic, and we do not have it now. So the crisis made it worse. In light of that context, the Public Defender's Office, but also CADU, have presented a lot of collective habeas corpus before different judiciary organs, before state court, before the Supreme Court, some of them, for example, in favor of people in the risk groups for illness resulting from COVID-19, some of them in favor of the people, of caretakers of people in the risk groups, some of them, for example, for people who, because of the pandemic, had the regime made more severe by the courts as means of isolation or means of precaution of contamination. So those are examples of collective habeas corpus presented in light of the COVID-19 pandemic, and they have been presented before, as I said, before different judiciary organs. Some of them were successful, some of them were granted, some of them were denied. What I think is the main point of this speech here is that it was a huge step for the Public Defender's Office, for the civil society in Brazil, and for the judiciary organs in Brazil to start looking at the prison situation, at the criminal justice system in Brazil as a collective issue, as a problem that should be looked at in a structural way in order to solve the problems. I cannot say, for example, the first habeas corpus I was talking about was presented in favor of women. We still have a huge number of women incarcerated in Brazil, and we still have terrible prison conditions of these women. Some of them, and a huge number actually, were released as a result of the collective habeas corpus, but we have been monitoring the impact of the decision, and we have seen that there is still judges in the first instance and the first degree which deny the liberty or the home arrest for the women in cases in which it should be granted. But we see that there is now some tension, there is now ways of reclaiming their liberty. There is now at least a consensus that this, at least in a legal level and in the high courts, that, for example, for the women who are pregnant or for mother of children up to 12 years old, that they should not be in prison. And of course, there is still a lot to do, but I guess it was a very important first step, and it was a very important first step if we consider the problems that came with the pandemic of COVID-19. So that's a little bit on the Brazilian situation. Thank you very much for your attention.
Thank you, Natalie, for highlighting these cases that are happening in the host country of Brazil. We are always happy when speakers highlight what is going on in the country of our ILAC hosts. And as we are already at the half-time mark, without further ado, I would like to pass the floor to Dr. Amar Dweik. He's the Director General of the Independent Commission for Human Rights of Palestine and has a very long and diverse national and regional career of experience with elections management, human rights, good governance, and of course, access to justice. He holds a PhD in social policy and management, a master's in law and government, and a bachelor in law, as well as a diploma in police science from universities in Egypt, Jordan, and the United States. Before joining the ICHR in 2015, he taught courses of public policy and public administration at the Faculty of Law at Birzeit University. He also served as the Chief Electoral Officer of the Palestinian Elections Commission for several years, during which he managed the presidential elections and the parliamentary elections. He is an author and co-author of numerous legal studies and reports, and was involved in drafting and co-drafting laws and bylaws in Palestine. He will talk about the ICHR experience in monitoring detention facilities in the West Bank and Gaza during the pandemic, and will also talk about the partnership with different stakeholders that ensure the prevention of and response to COVID in detention facilities and other places where people are deprived of their liberty. Dear Amar, you have the floor.
Well, thank you for the kind introduction. Hi, everybody. It's a great pleasure and honor to be with you today and to listen to what you have to say about your experiences, which of course I will learn from. To give you a little bit background about my organization, I work for the National Human Rights Institution of Palestine. It's an A status NHRI. We have a broad mandate. We combine a function of an ombudsman and a national human rights institution. And we have a mandate over inspection over prisons, detention centers, all places of deprivation of liberty, including safe houses for women under threat of violence. Also, we visit and inspect over mental health facilities, any place where liberty is deprived, we have access to, both in the West Bank and in Gaza. We have good working relations with the Palestinian ministries and authorities in the West Bank, but also we have a good working relation with Hamas Authority in Gaza. And we use these good relations in order to facilitate our work and to have access to prisons and detention centers. Palestine joined the optional protocol on the OPCAT in 2017, but has not yet established the NPM, the National Preventive Mechanism. And in the meantime, ICHR acts as the de facto National Preventive Mechanism for Palestine. We roughly conduct over 1,000 visits to detention and prisons, detention facilities and prisons in the West Bank and in Gaza. This is under normal circumstances. Early in March, and after the spread of the virus and the early cases reported in Palestine, the government announced a state of emergency. And the state of emergency in general is perceived by human rights organizations, particularly in our region, with great suspicion. We are always concerned about using or abusing state of emergency by state authorities to commit other human rights violations. So we are keeping a close eye on the conduct of public authorities under the declared state of emergency, which is renewed on a monthly basis since it was declared early in March 2020. We give particular attention to persons in detention and prisons. And when I talk about persons in detention and prisons, I mean Palestinians in Palestinian prisons under the jurisdiction of Palestinian authorities. We are talking about, in normal days, we have inmates about 1,500 prisoners in the West Bank and the same number in Gaza. We are talking about a population of 3 million people in the West Bank and 2 million in Gaza. So you can do the math about the rate of incarceration. I'm not talking today about Palestinian prisoners under Israeli prisons. We have 6,000 Palestinians arrested and detained by Israeli authorities, and they are held against international law inside Israel and not in the occupied Palestinian territory. we don't have jurisdiction to follow up on their situation, but we made appeals about our concern about their health and safety because of the lack of transparency of the work of Israeli prison officials and prison administration. I will talk about our experience in dealing with Palestinian prisons, both in the West Bank and in Gaza, since the declaration of state of emergency and since the early cases of COVID-19 reported in Palestine. We are a member as an Independent Commission for Human Rights of a justice sector working group. This working group includes Minister of Justice, Chief Justice, Attorney General, Head of Bar Association, Head of Police, and myself representing the Independent Commission for Human Rights. Within the framework of this committee, we agreed early in March to propose a plan to substantially reduce number of inmates in detention centers. And our strategy has resulted in a reduction of 35% of inmates in the West Bank, while in Gaza, Hamas authorities, with our advice, they reduced the number to over 50%. The percentage of people they are being released since the COVID-19 is around 50% in the West Bank and around 50% in Gaza and around 35% in the West Bank. And this strategy including the following. First, we encouraged the president to issue a pardon for all those who serviced over half of their sentences, particularly in non-serious crimes. The president pardoned around 130 inmates in the West Bank. Second, the president issued a law by decree upon our recommendation of the working group, the Justice Sector Working Group, and this law suspended the provisions in the enforcement law that allows detaining persons on contractual obligation. It's unfortunate that until today in Palestine, we still detain people or arrest them on contractual obligation in violation to the Covenant on Civil and Political Rights. Around 25% of inmates in Palestinian prisons in the West Bank, they are arrested or detained on grounds of contractual obligation. So the president suspended this provision temporarily, with the exception of those who are detained for amounts that exceeds $150,000 US. Third, the Chief Justice and the Attorney General, they encouraged judges and public prosecutors to release prisoners on bail, particularly in non-serious crimes. And we have seen like positive responses from judges and public prosecutors in this regards. The second thing in our strategy was to work in partnership with the Office of High Commissioner for Human Rights and different stakeholders to devise and develop guidelines related to the pandemic and the human rights. We issued several guideline notes. The first one was entitled Deprivation of Liberty and the Outbreak of COVID-19. This guidelines was developed in coordination between the Independent Commission for Human Rights, the Palestinian Ministry of Interior, and the Office of High Commissioner for Human Rights. In this detailed note, which was distributed largely to police forces, to security forces, to prison officials, we talked about what are the limitations on the state of emergency under international law. We talked about prohibition on torture and ill-treatment. What are the fair trial guarantees for persons in detention during the COVID-19, and how we balance between fair trial guarantees and preserving the health of prisoners. We talked about the right to universal health care for prisoners and what are the criteria for that, the right to legal counsel, and alternatives to detention. In addition, we talked about access to information for prisoners, condition in detention facilities, and communication with the outside world. Additionally, in these guidelines, we detailed the special rules for treatment of juvenile and women. And finally, in these guidelines, we elaborated about rights of persons in health quarantine. At the beginning of the pandemic, the government allocated several places, including hotels, schools, for persons under health quarantine, but now the quarantine is done at home. At the beginning, there were hundreds of people in quarantine, so we consider them also persons deprived of their liberty, and they deserve attention. So we elaborated about what are their rights and what are the responsibilities of the government towards them. We also issued a leaflet and distributed to persons under quarantine, and also we made a short video and we provided them with numbers of our representatives in case if they have any complaint that we can follow up. We also devised another guidelines in coordination between us, the Office of High Commissioner for Human Rights, the Ministry of Justice, the High Judicial Council, the Attorney General Office, and the Bar Association. Under these guidelines, which was entitled Justice and COVID-19, a guide for judges, public prosecutors, and lawyers in Palestine. In these guidelines, we talked about what are the obligations and responsibilities of judges, public prosecutors, and lawyers during the COVID-19 towards citizens and persons that are in contact with the justice system. We talked about fair trial guarantees in details, about death penalty, the right to life during the pandemic, the privation of liberty for exercise of freedom of expression, for the violation of restrictive measures during the COVID-19, and right trial by civilian courts, the role of judges, prosecutors, and lawyers with regards to arbitrary detention and the prohibition on torture and ill treatment. We also talked about alternative detention and complaint mechanisms. These guidelines were adopted or endorsed by the Chief Justice, Attorney General, Minister of Justice, and was distributed to workers in the justice system. I can say now that in Palestine, the good news is that so far, alhamdulillah, until today, there has been no cases reported of COVID-19 inside detention centers in the West Bank. We are talking about 35,000 reported cases of COVID since March, 0 cases in detention centers until today, or at least 0 cases reported until today, which is very good news. In Gaza, we have 6 cases that were reported, and they are now in quarantine. Despite this good news, there are still some problems and challenges. Despite the fact that the overcrowdedness has been substantially reduced, we still have overcrowdedness in certain centers, particularly in temporary detention facilities. Also, we see a relaxation in the measures taken by prison officials. People got used to the pandemic, and therefore it seems that they are now taking it less serious than before. So we see that reflected in the behavior of prison officials, and that raises concern about possibility of transmission of the disease to the prisoners. We still receive cases about ill treatment and torture in detention, especially during the interrogation period. And we have concerns about the continuation of these cases. We have concern about the prolonged adjudication process. Justice is now delayed because of sometimes courts are closed or restricted. Also, we are concerned that judges, they tend to renew the detention for a longer period because holding court sessions is a little bit difficult under their circumstances. Palestinian law does not allow for remote sessions or remote court sessions. Therefore, prisoners have to be brought in person to the court. That exposes them to risks of contracting COVID-19, but also in many cases, sessions does not take place, and therefore they continue to be in prison. We have concerns about increase in the number of prisoners based on freedom of expression. Given the difficult economic and political situation in Palestine, we see an increase in resentment among public about the conduct of public institutions, and public institutions are becoming less tolerant to opposition, and we see more people detained because of expressing their opinions. We are concerned about the health situation in Gaza in general. Gaza health system was near collapse before the pandemic. We don't believe that it can afford a long pandemic. And the situation in prisons, they have very weak and poor capacities, very poor health capacity in prisons in Gaza. There's overcrowdedness despite the fact that they released over 50% of prisoners. And we are concerned that if, God forbid, if there is more cases of COVID-19, that might lead to serious problem.
Mr.
This is
Ammar,
sorry, I took maybe over more time, but this is the nutshell situation in Palestine, and I'll be happy to answer your questions. Thank you.
Thank you very much. Wait, I have not switched on my video. Thank you very much. This was so impressive. I think the list of all the, particularly in addition to all the other things you said, the points that you mentioned on the strategy that you followed, that the committee, the working group came up with, and that was supported by all the authorities. And of course, also the list of the guidelines that you really very impressively read out to us. It reads like a list of what countries should be doing, actually. So very happy to hear that, and very happy to hear the high success rates of release of prisoners and keeping them safe from contracting the virus. As we are already reaching the last 30 minutes, I would like to now hand the floor to our final speaker, Mr. Mabrouk Khoualdi, the Director of Criminal Cases and Human Rights at the General Committee for Prisons and Rehabilitation at the Ministry of Justice of Tunisia. Sorry, I hear some other sounds. I hope you don't hear them. Mr. Khoualdi has a very impressive 25 years of work as a lawyer with the committee and held different positions, including the deputy directorship, where he was responsible for preparing the release of detainees. His current duties as a director include responsibility for supervising the legal review of documents that lead to imprisonment and in also rehabilitation centers, and to ensure respect and applications of human rights standards in these places. He will share with us today a variety of points regarding the measures taken in Tunisian prisons and detention facilities to improve the conditions, avoid overcrowding, and reduce the risk of contamination. He will talk to us about challenges while ensuring lawyers and the National Preventive Mechanism have free access. He will furthermore address how the suspension of work of the courts affected the situations. You have the floor.
في البداية أود أن أتوجه بالتحية لجميع المشاركين في هذا المؤتمر، ثم أتوجه بالشكر للساهرين على تنظيمه، وشكر خاص أيضا لبرنامج الأمم المتحدة الإنمائي بتونس لإتاحة أو لتوجيه الدعوة لوزارة العدل للمشاركة في هذا المؤتمر. سوف نتعرض أو نتقاسم معكم التجربة التونسية فيما يتعلق بالتوقي من فيروس كورونا داخل السجون التونسية. وفي الحقيقة سوف نتعرض إلى أهم النقاط عديدة هي الإجراءات المتخذة من طرف وزارة العدل والهيئة العامة للسجون والإصلاح. وسوف نتعرض في البداية إلى الحد من الاكتظاظ داخل السجون التونسية. في الحقيقة مشكل الاكتظاظ في تونس كأغلب الأنظمة العقابية في العالم تشكو السجون التونسية من الاكتظاظ، وكحل تم اتخاذه من الدولة التونسية ووزارة العدل هو التقليص، ويكون في إطار مدروس، وكان في إطار العفو والسراح الشرطي، مع بطبيعة الحال دراسة وفقا لمقاييس موضوعية، مع إعطاء الأولوية للفئات الهشة أو المساجين المورطين في قضايا بسيطة ولا تكتسي خطورة إجرامية، حيث تم تمكين حوالي 4000 سجين من العفو والسراح الشرطي. وهذا الإجراء ساهم في التقليص من الاكتظاظ. نظام الإقامة في تونس هو نظام جماعي، ومخاطر العدوى عالية، ولذلك تم اتخاذ هذه الإجراءات وخاصة التقليص من الاكتظاظ. ثم النقطة الثانية هو تنظيم عملية التواصل مع العالم الخارجي، فتم تعليق الزيارات المباشرة من المساجين لأهاليهم والاقتصار فقط على الزيارات بالحاجز مع تحديد عدد الزوار. أيضا من بين الإجراءات هو قبول المؤونة من عائلة السجين مرة واحدة في الأسبوع، بينما كانت في الظروف العادية 3 مرات في الأسبوع. بطبيعة الحال تم الترفيع في الاعتمادات المخصصة لإعاشة المساجين تحسباً لأي نقص على مستوى التموين. تم اتخاذ أيضاً جملة من الإجراءات ذات الطابع الاجتماعي والنفسي بالأساس، وتهدف هذه الإجراءات بالأساس على المحافظة على الروابط الأسرية، وهذا من شأنه أن يطمئن المساجين على عائلاتهم، وأيضا يطمئن عائلات المساجين على ذويهم داخل السجون. وأولينا عناية خاصة بالمساجين ذوي الفئات الهشة، وخاصة الأطفال، الأجانب، النسوة، كبار السن. بالتوازي مع هذه الإجراءات أعددنا ونفذنا خطة اتصالية متكاملة حول أوضاع المساجين وأوضاع السجون، وكانت لنا العديد من الندوات الصحفية ونشرات إعلامية، سواء بوسائل الاتصال الرسمية أو الإذاعات والتلفزيونات الرسمية أو الخاصة، وأيضا بوسائل الاتصال أو التواصل الاجتماعي. إذن بعد التقليص من الاكتظاظ وتنظيم عملية التواصل مع العالم الخارجي، وضعنا كمجمل الأنظمة السجنية والعقابية إجراءات صحية وقائية صارمة كما قلنا، باعتبار أن نظام الإقامة داخل السجون التونسية هو نظام إقامة جماعي، فلا بد من اتباع إجراءات وقائية صارمة للتوقي من مخاطر انتشار العدوى. الإجراء الأول الذي تم اتخاذه في هذا المجال الصحي هو تخصيص سجون أو عدد 6 سجون لاستقبال المودعين الجدد للرجال، وسجن خاص باستقبال المودعات الجدد من النساء. إثر عملية الاستقبال لابد من إخضاع جميع المودعين الجدد إلى فترة الحجر الصحي. من بين الإجراءات الوقائية أيضا تخصيص مسالك إجبارية للمودعين واتباع إجراءات وقائية تخص ظروف الإقامة. قمنا أيضا بتوفير مستلزمات النظافة والوقاية والتعقيم بالكميات الكافية، وقد تعزز مجهود الوزارة أيضا بمساهمات المجتمع المدني والهيئات الرقابية المتداخلة. أيضا تم تخصيص سجن جديد واستغلاله كفضاء للعزل الصحي خاص بالمصابين بكوفيد 19. وبطبيعة الحال تم تجهيزه بجميع المعدات الطبية اللازمة. كما قمنا بتكثيف الحملات التحسيسية والدعم والإرشاد، خاصة الإرشاد الجزائي لفائدة المساجين، وأيضا قمنا بحملات تحسيسية لطمأنة عائلاتهم. قمنا أيضا في هذا الإطار بإعداد بروتوكول مشترك مع وزارة الصحة للتوقي من فيروس كورونا. الإجراء الرابع الذي قامت به الدولة التونسية والمتعلق خاصة بالمحاكمات، فقد تم تنقيح أو تم بداية من شهر مارس 16 مارس 2020 تعليق العمل بالمحاكم باستثناء الأمور المتأكدة والمستعجلة. وتواصل هذا التعليق إلى حدود 4 ماي 2020، ولكن دون التقصير من طرف الهيئة أيضا وحرص من طرف الهيئة على إحضار جميع المسجين الذين تتم دعوتهم للوصول
if I may ask you to find to come to an end. If possible. No, you have to come unfortunately to an end because we have 14 minutes now for the Q&A. Is that okay? You can all, thank you. Thank you very much. This really shows another aspect of what we have seen in addressing COVID-19, that not only all the measures have to be done to decrease overcrowding, but also really to create mechanisms that look at the family and the lawyers and the contact with the outside world. And what you say about informing the public in press conferences about what is going on in the prisons, how they can access it, to have awareness raising campaigns, to ensure that also the families of the detainees keep in mind the measures to decrease the risk of COVID-19. This is incredibly important, and I'm very happy to hear that you have done so much work on this. Dear participants, we have only a few minutes left, so we will not be able to address all of your questions, but I would say that we ask one of them that can be answered by all the participants. So I would say that I pose this question and we go in the speakers list, and starting maybe with Olivia to see if you would like to address that. But before that, I would like to ask Amar and Natalie. People have been asking in the chat if you would be willing to share, Natalie, your PowerPoint presentation, and Amar, if you could give input on your, let me just look at it, your list, your checklist and the strategy that you followed. That would be really very useful for participants. So if you would be willing to share any points later on, we would tell the participants that are interested to write to the general ILAC email address so we can share this with them. That would be great.
Actually,
and now let me go to the question, please. And it was posed by Maturima from the Commonwealth Human Rights Initiative. And she asks, what do panelists think are the priority areas of engagement going forward with COVID-19 impacting prisons and prisoners' rights in almost all jurisdictions? What do you think? Maybe each of you can say one thing that you think now, as the pandemic has been going on for a while, second waves are coming. What do you think is the most important point that should be addressed? Thank you.
Thanks, Anika. I'm happy to answer that. And it's hard to pinpoint one priority, but I think one thing that hasn't been mentioned much today is an investment in healthcare. So before the COVID-19 pandemic, overall, we could see that globally, most prison systems had underfunded and inadequate healthcare systems. And those that were under the Ministry of Health, so where prison health was governed and kind of the responsibility was under the Ministry of Health, we have seen that there has been better coordination, better access to key equipment, even kind of hygiene, basic hygiene equipment and soap and things like that. It was easier to coordinate and easier to get the healthcare expertise that you need during a pandemic. And so I think moving forward, there needs to be an investment for physical health and also mental health care of people in detention who disproportionately have poorer health status than people in the community. And maybe just a final word that's kind of linked to that is that if you have overcrowded systems, if you have the kind of rates that we just heard about in many states, including Brazil, then you just cannot, you cannot meet the basic healthcare needs, let alone respond to this kind of pandemic. And legal aid is really critical in bringing down prison populations, as is kind of efforts to reduce sentences, and crime is not going up, but the prison populations are globally. So we really have to question why that is and challenge it.
Thank you very much.
I'll leave it there.
Thank you very much. All very good points. Bruno, would you like to add? You will have to unmute yourself. You are still muted. I didn't hear.
Oui, désolé. Non, je pense que tout a été dit juste ici. C'est gentil.
Bruno, would you like to make an intervention?
Non, je disais que je n'avais pas d'autre chose à ajouter à ce moment.
Okay, merci. Okay, we could not hear. Okay, Amar, would you like to make a statement?
Yes, sure. Concerning the notes that I mentioned about the guidelines, Actually, we prepared 5 guidelines, one for about the people deprived of their liberty, one to justice sector, one about women, one about children, and one about persons with disability. And in all these guidelines, we talked about how to address the needs of these groups
We're
within
not
the
getting
pandemic,
translation
taking
on the
human rights
English
approach.
channel.
I will share with you these 5 notes about what our priorities. I believe it's the priority is how to balance between right of inmates to communicate with the outside world and see families, lawyers, and visitors from outside. At the same time, how to prevent the spread of the disease. And this is how to strike this balance. And I think this should always be carefully revisited and depending on the health condition in a given country and given on the legal framework. In Palestine, we have additional problem. We have the economic crisis, we have the pandemic, we have the occupation. And now, because of recent political development, we cannot move prisoners from one city to another because there's no coordination between Palestinian Authority and the Israelis for political development. And the Israelis refuse to allow Palestinians to move prisoners from one city to another. Some prisoners are held in one city and they face trial in another city. So that means that many prisoners cannot move, and therefore they are held in custody for a long period of trial. So our priority is to come up with legal solution to this problem in order to shorten the period of trial, to make it like justice served within a reasonable time. Thank you.
Thank you very much. Then I would like to ask Natalie if you want to have the last word, and if you give me 2 minutes, that would be great in the end. Thank you.
Yes, of course. Thank you very much for all of your questions and comments. I was reading them here in the Q&A. I guess it's no surprise for us in Brazil that the COVID made the prison still worse. The Brazilian prison system had no conditions to face such a pandemic, of course. We are talking about overcrowded places, about lack of access to healthcare. So I guess what's urgent now was urgent 2 years ago. It's to reduce the prison populations, to apply the alternative measures who are still in the law in Brazil, to improve health facilities and to avoid applying the prison before a conviction, which is already a rule in Brazil. So I guess COVID pandemic just made it more urgent that we look into the prison system and address it like the serious issue that it is. Thank you very much.
Thank you very much. And this is, as I said before, when we heard the strategy list from Amar, for example, and also what Olivia said at the beginning and what many of you mentioned, what the presentations today have really shown, that there are a lot of measures that we all agree on should be taken on board, and events like this really help to spread the words amongst the practitioners. And I think many of you listening as participants are legal aid providers, are lawyers, paralegals, working in ministries or in law firms, wherever you are based. So really, the thing is to really spread information and share experiences that you learn from other countries, so that the decisions that are taken are informed. And this is a big deal of why we created ILAC in the first place, and why we keep it running, to give you a platform to share experiences with people from other countries. And I would like to thank all the panelists very much for sharing all these details about what's been going on in their countries and at the international level as well. I would like to also thank the audience for engaging. I saw that there were lots of people in the chat writing. As I said, if Natalie and Amar would share with us some documents, please, if you are interested in receiving any information that you could get after this panel, write an email to the general address of ILAC 2020 that you will find on the website, and let us know what you would be interested in, because we cannot take this information from the chat. Finally, I would like to invite you to join again at the same time tomorrow and on Wednesday in the other panels that discuss different topics that are for your time zone. With the link that you got to register overall, you will be able to access all of these. And I would also, of course, invite you to join, if you cannot make it to the panels in the coming 2 days, the closing session, where we will have a collection of points that came up in all the panels to see what were the highlights that people think are important to be addressed right now, as we are facing, and we are still in the middle of this global crisis. We are even now 1 minute short, so we really have kept well with the time. Thank you again so much for engaging. If you are interested in hearing the Latin American perspective, and it is not too late in your time zone that you are currently in, we of course welcome you also to join the panel that starts in, if I'm not mistaken, 1.5 hours from now, where we will also have some interpretation. You can check the website for that. And with that, I thank everybody again very much. We are very happy to see that there is such an interest, and I wish everybody to enjoy the conference and the panels that remain. Thank you, and greetings from my home office in Italy. Bye.